Hi, everyone. Thank you for your patience. We're very excited to have you here, and I'm excited to introduce Pete Wright. So for those of you who may be new to August Schools, we're a documentation platform built for student support teams. Our goal is to make it easier to securely document sessions, identify trends in student needs, and use that data to guide proactive programming. So the work you do every day is essential, and we're grateful to support it, not just through our platform, but also through webinars like this one that brings together thought leaders and practitioners for meaningful discussions on critical topics. It is my privilege to introduce Pete Wright, a nationally recognized attorney, author, and advocate for children with disabilities. Pete's passion for this work began with his own experience as a student with dyslexia, dysgraphia, and ADHD, an experience that inspired his lifelong dedication to ensuring every child receives the education and support they deserve. As the co-founder of Wright's Law, the leading resource for special education law and advocacy, Pete has spent decades training educators, attorneys, and families across the country. He argued before the U.S. Supreme Court in the landmark Florence County School District versus Shannon Carter case. He co-authored several foundational texts on special education law and continues to teach and train through the Special Education Advocacy Summit at St. Mary's University School of Law. Before we get started, just a quick note about today's format. The first 45 minutes will be Pete's presentation, followed by about 15 minutes for Q&A. As questions come up, please type them in the Q&A tab. You don't need to wait until the end. And then at the end, we'll gather as many as we can for discussion in the final portion of today's webinar. So please join me in welcoming Pete Wright.
Thank you, Chloe. It's a real pleasure and it's an honor to be doing this training today. I have been through the website, August Schools, and you all are on the cutting edge. I have looked at a number of your webinars and been through some of the other resources that you offer to schools, and it's awesome. It's very impressive. So I'm honored and pleased to be out here with you all who are doing the cutting edge. So perhaps maybe I will be part of the cutting edge. So what we're going to do now is I'm going to go to the first slide, just the title slide. And then I created on our website a subdirectory. So these slides that you're going to see today, you don't have to take screenshots of them or anything of that sort, because I'm going to make them available to you. They will be in a subdirectory, and it's on our website, wrightslaw.com. And then the subdirectory is simply 2025 August. And the slides, I'll put them up there in both color and black and white. They'll be zipped so that you'll have to download and then double click to unzip. And then some other files I put up there also. Normally when I do a Wright's Law Special Ed Law and Advocacy training, is typically about 6 hours long. Sometimes they're 9 and sometimes they're 12, but typically 6 hours. And I have a lot of slides, and the audience also has all of our books in their hand. So I go through the books on screen with the audience and have them highlight various statutes and write notes in the margin, etc. So we're not doing that, of course, today, but I do have some information up there on our website. Now, the files that are on our website in that subdirectory, 2025 August, they're also elsewhere on our website. They're in other locations. So I put some of the ones that I thought would be pertinent for today in together there. So the agenda: demystifying the law, partnering with families to move from conflict to collaboration, researching how to find cases specific to the issue you're wrestling with, and being able to not only read a case, but to go into the court's file and open up the court's file, the complaint filed in the U.S. District Court, the briefs that were filed. Sometimes it may be the exhibits, oftentimes the exhibits and even witness lists, etc. So I'm going to show you how to do that. But first, before we get into the primary content, a little background. Who is Pete Wright? Well, I attended DC public schools from kindergarten through the 11th grade. DC public schools told my parents in kindergarten that they thought I was mentally retarded, emotionally disturbed, and uneducable. And my parents got a comprehensive evaluation from George Washington University, found that I had streptosymbolia and an acute hyperkinetic disorder. Streptosymbolia later changed to dyslexia, dysgraphia, dyscalculia, and the acute hyperkinetic disorder, now ADD, ADHD. They were advised to find Orton Gillingham tutor to teach me how to read, write, spell, and do arithmetic. They found Diana Hanbury King. Diana was just starting out, and I was one of the first kids she ever worked with. I ended up having 2 years of intense one-on-one remediation using the Orton Gillingham approach from Diana Hanbury King, who later became internationally famous, founded the Kildonut School, the Orton Gillingham Academy, and other things of that sort. Whoops, I didn't mean to do that. I want to go back to the slide. So I hit something wrong. Bear with me. It's a new platform that I'm not that familiar with it. I have a YouTube. Normally, when I'm doing my live face-to-face 6-hour program, I open up my report cards and put them up on screen and go through some of that. They are part of a YouTube video. We've got about a dozen videos up on YouTube and Wright's Law channel. If you go up there, you'll be able to see my report card. And also Diana King talking about dyslexia. The most important trait about it is, and it's an awesome discussion that I had with her, interview I had with her. She's a genius. I am not your typical adult dyslexic who has problems with reading, writing, arithmetic, and spelling. Her goal was to get me 2 years above age and grade level. I was given another comprehensive psychoeducational when I was in the 6th grade, and in all domains, all educational achievement domains, I was at the 8th grade or higher than 8th grade. Streptosymbolia, Dr. Orton presented a paper in 1925 called Word Blindness in School Children. And that was when it really came into being. Oops, I'm hitting the wrong thing here. Trying to go to the next slide. Hey, he's putting me back up there. For more, we've got several articles on our website. I argued the Carter case before the U.S. Supreme Court, October 6, 1993. The decision was unanimous in our favor, pro-child decision. It changed the landscape in the field of special ed, and also not just dyslexia, but changed it with autism. At that time, there were battles between parents and school districts about what technique, what approach to use with kids who had autism, whether it was the teach method or the floor time method, or this new thing called ABA, Applied Behavioral Analysis. And it really opened the doors to parents being able to get reimbursed for ABA. So 3 generations of the Supreme Court. The 3 generations, myself having dyslexia, my client Shannon Carter, and my tutor at camp, and later president of the Orton Dyslexia Society, Roger Saunders. So I have an article about all of that in the history of the untold story. There was a downside to the Carter case. I call it the curse of Carter, because after the Carter case, school districts got away from having clear, specific, measurable objectives in the IEP goals. All right, let's get to the next slide here. No, the wrong way. Okay, demystifying the law. There are 3 statutes that are related to kids' education, mental health. Kids who have mental health issues will typically be eligible for protections under the Individuals with Disabilities Education Act, possibly, or the Americans with Disabilities Act, and or Section 504 or the Rehabilitation Act. If there are mental health issues with a kid, then one of these 3 or all 3 of these statutes may apply. For example, if a kid has a particular disability and that disability adversely affects the child's educational performance, then that child would be entitled to an IEP. if the child has a disability and it does not adversely affect educational performance, but it's still a disability such as an episodic one, whether it's allergies, ADD, ADHD, then the child is entitled to protections under Section 504 and also the Rehabilitation Act. When you look at a statute or a regulation the first time, I recommend, well, and you're really trying to wrestle with trying to find the answers, I recommend having a print version. Maybe just print the one you see online on screen, but have a print version. Now, when statutes and regulations are issued, whether it's a statute, a code by a legislative body signed by the president or by the governor, or it's a regulation issued by the department of such and such, when they are issued, many times everything is text left. When it's text left, it's easy to get confused as to what is a subsection of what. And many mistakes are made by practitioners who don't understand the importance of doing one step first. The first time you look at a statute or a reg and you're really trying to digest and understand it, take your highlighter, highlight the title, such as 20 U.S.C. 1400, the special ed law, and that's findings and purposes. Then look at the very next line below that, the first part of it, and it will have lowercase a, or it might have a digit 1 or capital letter A, or it might be Roman numerals. However, whatever it is, see how it's set up. And so then highlight that. For IDEA, it's lowercase letters, except for definitions, it's lowercase letters. So you highlight that, that's A, lowercase a. Then you do not read for content. You scroll and look for lowercase b, highlight that heading, that B in the heading, then look for lowercase c, and then look for lowercase d until you have highlighted all the major subheadings. Then go back to the one you're interested in. And if it has a bunch of subheadings underneath that, subsections under that, highlight those first, then you go in and read it. It's a habit that you really want to develop in the beginning, and it'll save you from making some big mistakes. And I've seen some big mistakes sometimes made because people thought so-and-so statute said so at such and such when it was a subsection of another statute and it was totally unrelated. I was going to give you a demo in our law book, but we're having problems with the share screen and not opening up the law book for you to see what I'm talking about. So we'll skip that part. So the special ed laws, IDEA, Section 504 of the Rehabilitation Act, Americans with Disabilities Act. Question, Chloe, if you can hear me and respond. I see that your mic is turned off. As I'm talking and I'm moving my mouse, can the viewers see my mouse as it's moving to a particular area in the slide?
So I don't believe so. Can you move it one more time?
Okay, that's fine. I just wanted to know that.
Yeah.
So, all right. So then state regulations, the key law you want to look at when you're wrestling with a legal issue is what is in the United States Code. Then after that, you look at what did the Department of Education say with the regulations that they issued. They are in the Code of Federal Regulations. So then you want to look at that second. Then third, you want to look at your state statutes or state regs. Typically, state statutes are very minimal, not much content, and defer more to the state regulations. And some state regulations simply say, our state regulations are incorporated by reference to include and be the same as the federal regulations, but not always. Sometimes they have much more specificity. The law does permit states to have more detailed and specific regulations, primarily with regard to procedural issues, but state statutes and state laws may not take away rights provided by federal laws. That's because of what's known as the Supremacy Clause of the U.S. Constitution. When a law is issued by a legislative body, and typically by our Congress, it will open with what were the findings of Congress based upon testimony that they had. And then the next critical part will be, what is the purpose of this law? And then it will be followed by definitions. What's the definition of a child with a disability? What's the definition of a free, appropriate public education? What's the definition of related services, et cetera? And then we'll get into the various rights and responsibilities that both citizens have and agencies have, state and federal agencies have. So what controls when federal and state law conflict? The United States Constitution, pursuant to the Supremacy Clause, has the federal law controlling. So always learn and understand what's in the United States Code first, then the Code of Federal Regulations second, and then you look at your state law. Common acronyms: FAPE, Free Appropriate Public Education; LRE, Least Restrictive Environment; IEP, Individualized Education Program; ESY, Standard School Year; IEE, Independent Educational Evaluation; FBA and BIP, Functional Behavioral Assessment, which then will lead into a BIP, a Behavioral Intervention Plan; LD or SLD, Specific Learning Disability; and HFA. Those are just some of the ones that we see more often. IDEA has 5 key statutes. The first one is the findings of Congress and the purpose of the law. The next one are the definitions, defining various things. Then 1412, state responsibilities. And it also has in there what is FAPE, what is child find, least restrictive environment. Then 1414 is the one statute that people will look at probably more often than any others. And that's the one that has all of the law of initial evaluations and the timeline to complete an initial evaluation and what determines eligibility, and also triennials and reevaluations, and all the law of IEPs. That's in 1414. 1414, subsection D is the law of IEPs. 1415 has all of the rules of procedure, going to court, due process hearings, getting independent educational evaluations, and also a lengthy portion about discipline. So when I do my live program, the audience has already turned to page 88 in the law book, and they will see the findings and purposes, and they've already highlighted all the main subsections at 1400. That would be A through D. And again, repeating the same concept. Many times when something is issued, it's full. So if you disability is a natural part of human experience. No way diminishes the right of individuals to participate in or contribute to society. Improving educational results for children is an essential element of a national policy of opportunity, equality of opportunity, full participation, independent living, and economic self-sufficiency. So I had the audience highlight economic self-sufficiency in their law book, because that's one of the key things you have to be thinking about when you're wrestling with a goal, an objective, or how to resolve a conflict issue. Well, what is it going to take to help this youngster become economically self-sufficient? Congress also wrote that this law has been impeded by low expectations and insufficient focus on applying replicable research on proven methods of teaching and learning. And then we have a number of footnotes in the book, and words in bold, as you can see. Congress did not put footnotes in the law or put words in bold. Almost 30 years of research has demonstrated. Now, this law was passed in 2004. It was originally passed in 1975 and then has been modified and amended over the years. Before the 2004 version, it was 1997. So people refer to the older law as IDEA 97. Now we're dealing with IDEA 2004. And there's some discussion that it will be revised, portions of it, but there's no great movement taking place yet. When it is revised, it's not going to be rewritten globally. Instead, there'll be little changes, maybe some changes of substance, but it's not that you have to learn this all over again. For example, in the 2004 version, it said almost 30 years of research. And of course, that's going to change. All right. It can be made more effective by strengthening the role and responsibility of parents and ensuring that special ed can become a service. So often when we're wrestling with what to do for a youngster, what's appropriate, what does a kid need, Well, give me the kid's label. Oh, okay. Well, the kid he has ADD. He's in a chair, and he also has LD issues. Oh, well, if he's in a chair, he goes to the CSEP Center. That's the campus style building. No floors. But you said he also is an. You said he's an HFA, the high functioning autism, because they don't go to CSEP Center. No, they go over to so and so school on the other side. In other words, you start thinking, give me a label, I'll give you a place, and that's not how it's supposed to be. Instead, special ed is a service rather than a place where they are sent, and so easy to get away from that concept. So be careful about that. And here is the purpose of the law: to ensure that all kids have FAPE that emphasizes special ed related services designed to meet their unique needs. So that's key, meet their unique needs and prepare the child for further education, employment, and independent living. So again, when you're wrestling with a goal and objective in an IEP, or how to resolve a discipline matter, whatever it might be, go back to the purpose: economic self-sufficiency, prepared for further education, employment, and independent living. This is the mission statement of the entire law. And to ensure that the rights of the parents are protected. Second primary purpose: protect the rights of the parents and the kids. Child with a disability means a child with, and then it lists a bunch of different characteristics, and who by reason thereof needs special ed and related services. And the case law has said the disability has to adversely affect educational performance, and that's in the footnotes in the book. The regulation issued by the Department of Ed about that statute is more detailed and more specific. It goes on for 2 pages. When a kid has an IEP and moves from one jurisdiction to the other, the child is entitled to services that are comparable to those in the prior IEP. Comparable means similar, equivalent. We discussed this in the book, and it's also in the what's known as the commentary. If the child moves from one jurisdiction to another jurisdiction in a different state, that new jurisdiction has to also do an evaluation. But if it's a within state transfer, they're not required to do an evaluation, but they may, and many do. Another one that pops up frequently, especially when you're dealing with mental health issues and behavioral issues, has to do with both special factors and whether or not there has been a functional behavioral assessment, and from that, a behavioral intervention plan. And we explain both in our law book here and also in our IEP book. In Chapter 7, we talk about the special factors and FBAs and BIPs. Case law has been evolving now in the past 10 years or so, and it began up in New York, New England area, where courts made a finding that the initial eligibility evaluation of the youngster should have included an FBA. It had one that was characterized as a part of it, of the initial evaluation, an FBI, but the FBA was flawed. And from that flawed FBA, a behavioral intervention plan was created. That BIP, based on a flawed FBA, thus meant the kid did not receive a free appropriate public education going back to the date of being found eligible, and thus the child was entitled to compensatory educational services going back to the date of the original eligibility committee meeting, all having to do with FBA and BIP. And there's also a lot with regard to communication issues that's in this 1414 D3 about IEPs. And special factors, it explains, that have to consider positive behavioral interventions and case law. And this is what I explained just moments ago. And then subsection 4, communication needs. Failure to adequately address that has resulted in a clear violation of the Americans with Disabilities Act. And there's been a fair amount of litigation. It's really been increasing steadily over the past few years. And we have a book all about IEPs. It's a question and answer, a frequently asked question book. And that book has Chapter 7 is special factors. And so special factors play a big role when you're dealing with behavioral issues and mental health issues. So summing up, IDEA, there are 5 key statutes. It's got a whole lot more, but these are the ones that are primary for most practitioners working in the schools and working with kids with disabilities or with other kinds of issues. 1400, findings of Congress, the purpose of the law. 1401, the definitions. 1412, free appropriate public education, child find, least restrictive environment. 1414, the initial evaluations, eligibility, reevaluations, IEPs. 1415, all of the rules of procedure, discipline, independent educational evaluations, due process hearings, attorney's fees, all kinds of procedural things of that nature. So that's IDEA summing it up, overview. And again, the subdirectory on our website, and it's not password protected, it's just up there right now, 2025, and then the word August. And I'm going to put today's slides up there in an Adobe PDF compressed zip file format. It'll be two files, actually. One file will be black and white, and the other file will be color. So it depends if you want to look at it on your computer, color would be preferred. If you want to print it and you don't have a color printer, then the black and white would be preferred. And the slides will have links in them, as this one does, and they are hyperlinks. They are active, and they will work with the slides. And then I have other files also. And then this is only going to be up for a couple of days, and then I'll delete this subdirectory. And other than the slides, all the other files in the subdirectory are already on our website, but they're in different locations. So I thought I'd put them together for you here. So the other law, Section 504 of the Rehabilitation Act, incorporates, by reference to the Americans with Disabilities Act, its purpose is to protect individuals from discrimination, to provide access to services. 504 issue could be whether or not the child has an aid. Aid may be required. If it's not provided, that might be a violation of 504. And under IDEA, you cannot get dollar damages, but under 504 and ADA, you can get dollar damages for issues that might arise. So dollar damages are available under 504 ADA, but not under IDEA. And most specifically, if there's retaliation against a parent for exercising their rights on behalf of the child, where example being a parent doesn't agree to the proposed IEP and gets pressured by the school district and still won't agree. And there have been cases where the school district has filed anonymous complaints with protective services about the parent and their handling of the child. Those have come back and really bit the person in the rear end who filed those allegations or complaints with protective services. Several cases out there on that. And the parents were allowed to go after the school district and the individual employee or director of special ed personally. So we had both liability by the district and by the personal individual. And typically, educators in that scenario don't have insurance to cover something of that nature. So the eligibility for 504 protections has expanded significantly from earlier years because of changes in the Americans with Disabilities Act. A 504 child has the right of access to the schoolhouse and is to be provided with an opportunity to learn. The IDEA child is to have the same thing. The IDEA child with an IEP, but also is to have a free appropriate public education from which the child receives educational benefit. So IDEA equals 504 and ADA protections. 504 does not equal the IDEA entitlements. But eligibility is very, very broad under 504 and ADA. ADHD, allergies, asthma, diabetes, epilepsy, basically anything that is an episodic condition. So they be thinking episodic, and there may well be protections under 504 ADA. When complaints are filed with the Department of Justice or with the Office of Civil Rights, if it's a complaint about IEP being inadequate or failure to comply with it, OCR and the Department of Justice typically will not get involved in IDEA, IEP issues. But if they are clearly 504 and ADA issues, they will. And so we have a couple articles on our website in that regard. IEP under IDEA, Section 504 plan, what's better? When a kid is found not eligible for an IEP, school may offer 504 as consolation. is it really a consolation prize? Well, sometimes a youngster is better off with a 504 plan and not an IEP, because I have found in my practice, and I've been practicing special ed law since 1978, I found that too often, if a kid has an IEP, everything is dummied down, and the expectations for the youngster to push himself or herself really are lowered because the kid has a disability, and that is not helpful. And in many instances, what may be better for the youngster is a 504 plan, and for the parent, if they can afford it, to get a private tutor, such as I had. Diana Hanbury King working Orton Gillingham with me, or maybe ABA, individual child with autism, and then continuing with just a 504 plan. But it's totally variable, depends a lot on the nature of the school district, the resources that are available within that geographical area, and also the parents' resource ability. Allergies, anaphylaxis, asthma, epilepsy. These are all episodic kinds of things. And if you're reading a case about a youngster that has asthma and your child has epilepsy, and you say, well, that doesn't apply to me because my child has epilepsy, stop. Read the case anyway and change the disability to the one your child has, or the one the child you're working with, because the manner of which the way the case unfolds and is resolved is pretty much same, and not disability specific. So don't have tunnel vision when you're reading cases. The Office of Civil Rights has a superb monograph, OCR resource guide. I put that up in that subdirectory, and I created a quiz from that. So these on the PDF version, these links will work. They're hyperlinks. And if you really want to get a handle on 504, take our 504 quiz. That will get you going in the right direction. The Americans with Disabilities Act. The Rehab Act was passed before the Americans with Disabilities Act, and then 504 has been amended several times and became the basis for the later 1990 Americans with Disabilities Act, and then ADA was modified again in 2008, and as a result of that, that has directly impacted 504. They both work together. The resolution of issues are so often the same. The disabilities covered are almost the same. They are kind of hand in glove with each. 504 typically will apply to public entities receiving public dollars, federal money, whereas ADA can apply to the private nursery school that receives no federal funding, and yet the child may have very significant protections in the private nursery school, or the private law school or medical school, or the bar exam for upcoming lawyers, or the medical exams. And we have several references to that in the law book under the ADA portion of the statute. And on our website, we have a number of cases up there regarding that. So in the ADA, Title II, you'll hear people say, well, this is a Title II ADA issue. Well, that's public schools. Then someone will say, well, this scenario here is about Title III, public accommodations. So when you're seeing Title III, think private schools such as private daycare, private nursery school, private university licensing board. Now, the ADA does not apply to schools, private schools that are controlled by a religious entity. So the ADA does not apply to private schools that are controlled, not located, for example, at a church, but controlled by the church. Control is the key. And this is the Americans with Disabilities Act in Title 42, United States Code, Section 12102. And it says what disability means: physical or mental impairment, a record of it, or being regarded as having it, and broad coverage and an impairment that can be episodic. McKinney-Vento. Now, I didn't have this in the agenda, but I decided, well, I do need to put this in here because we are seeing a lot of issues now with regard to homeless children. McKinney-Vento, homeless, the right to an education, the right to remain in the school of origin based upon child-centered best interest. So the decisions have to be based upon what's in the best interest of the child. So McKinney-Vento is a very powerful statute for the homeless child, and yet it's not utilized as often as it could be. So with the changes in the ADA in 2008, that best interest mandate of McKinney-Vento, many more legal tools are available to the homeless special ed child. If you really want to get a handle on some of these, find some cases out there and read the complaint that was filed by the attorney on behalf, and then read the decisions. And you can come up with what I refer to as creative Jerry Spence ways to tell the story. It's telling a narrative so that someone who hears the story feels, oh my gosh, oh, and it hits you in the gut. And when it hits you in the gut, then it hits you in the heart. And when it hits you in the gut, it hits you in the heart. That controls your intellect and logic as you analyze what should be the proper outcome, especially if you have the power to create the outcome. Once again, this is a directory. Okay, partnering with families. Parents who came to see me typically were really upset with the school district, furious, they're out for blood. And oftentimes they wanted revenge. And I had to shift their whole perspective and their personality to a Mrs. Manners, Peter Falk, Colombo, Mother Teresa. I had to remake them so that when they went to meetings, they were viewed in a different light. And that took a while. But when I did that, typically we got the case resolved. And I would tell my parents that it's not what the law says and it's not what the facts are. It's how the law is perceived by the person on the other side of the table, how the facts are perceived by the person on the other side of the table. So it's not law, it's not facts, it's not black and white. It's all about marketing and sales and persuasion. So I had my parents, and Pam and I were professors at William & Mary Law School for a year and a half to help them get their clinic operational. I had my law students read these two books, and with my parents, I drilled them on it. When they would come in to see me, I would go make sure that they had actually followed through. And one book is Getting to Yes. When you read this book, and you really it has to be read 3 times to get this stuff into your brain and operational. Then you start realizing how to use these not really tactics so much, but principles to the benefit of getting issues resolved. And the guru, who I just love to death, I heard him speak live 4 times. He was a master, never lost a criminal trial. He just died just a couple months ago. But the book title is How to Argue and Win Every Time. And that's really a misnomer. It's how to tell a story using visual imagery in a narrative chronological sequence that hits the listener in the gut and makes the listener, who may be the person with power on the other side of the table, want to come around to your side of the table and help you right the wrong. Very, very powerful technique. And that was his trial technique as an attorney. Awesome. And this is what Wikipedia says. Never once lost a criminal case, either as a prosecutor or defense attorney, and hasn't lost a civil case since 1969. So with those 2 books, you start thinking through, how is the person on the other side of the table thinking about this? What do they feel about it? And when my parents could say to the director of special ed, if I understand correctly your position, this is the position that you're taking, and the reason why is such and such, so on and so forth. And if you give me what I'm asking for, you are afraid of X, Y, and Z. And if the parent does explain it accurately, that is what the person fears and what the person feels and how they perceive it. If my parent is able, in a meeting with the school staff, and I didn't participate, I would get my parents to go by themselves. I did not become the mouthpiece at all. I tried to empower my parents to handle these and speak for themselves. When my parents did that, the person on the other side of the table says, oh my gosh, she understands our position. He understands our position. It's that we simply don't agree. But at least we all are on the same page on what the problem is and the fears each of us have. And that causes a polarization to go by the wayside, and it really shifts everything over more into an intellectual analysis as to solutions that both sides can be mutually comfortable with. Powerful technique. These books changed my practice, actually. So when you negotiate, you put yourself in the shoes of the person on the other side. How do they see it? How do they feel about it? What do they want? What are they afraid of if they give you what you want? That's the key. And when you can hit all four of those accurately, the polarization, the emotions go by the wayside. But know what you want, understand their position, have two interests: one, to solve the problem, but also second, protect the relationship. Don't let it go south, and keep your emotions under control. Seek win-win solutions. And listen more than you talk. Tell your story, ask questions, and always treat the other side with respect. So, partnering. Now, researching cases, and this is the fun stuff. This is the stuff I love. Google Scholar. Now, I hope that I will be able to go online and do this. Chloe, I may need your help to jump in here, because what we're going to do is we're going to research Google Scholar. So let me see. Let me open up in my browser. We'll see what happens. Okay, I've told it to open Google Scholar in a new tab. Now, do you see Google Scholar on your screen, Chloe?
If you go ahead and click on the present button, and then from there, share screen, and click that specific one, you should be able to share it.
Do you see Google Scholar now on screen?
I do. Let me share that with everyone. Okay.
All right, Google Scholar defaults to articles, so you always have to manually click on cases. And what I'm going to put in here is the Individuals with Disabilities Education Act. And you always have to put quotes when you put a phrase. Otherwise, every single time the word with comes up in a case, you'll get a case, you'll get a hit. We don't want that. We want all cases that have that exact phrase. And then I'm going to put in here mental health. And I'll put that in quotes. So that's what I want to search for. And where do I was actually, I jumped ahead of myself. I want to copy that into the memory for a moment. Where do I want to search it? Just in the federal courts? Just the Virginia courts? I'm located in Virginia, Deltaville, Virginia. So I'm going to click on this. I'm going to say select all state courts and select all federal courts. So now we've selected every court out there and done. And now it's going to come up with a search box again. So I'll just copy and paste back what I had. And then I'll say, go find it. And it gives you 1,400 cases in less than a tenth of a second. But I'm going to change it to not year, but sort by date. So I want the most recent on top. And let me scroll down to the bottom of the screen. And it says create alert. If I click on this tab, this button right here, it will ask me for my email address. And then anytime a case comes out in one of those courts that has Individuals with Disabilities Education Act, mental health, I will get an email link to the case. So what I'm going to do now is I'm going to right click and open this in a new tab. And hopefully you'll see the NEA versus New Hampshire. Chloe, can you confirm that that's what you see on your screen?
Yes, that's what I see.
Perfect. Okay, good. So this is working out all right. All right. So this is a case. And I searched for IDA and mental health. So I'm going to do Command F and search for mental health.
Oh, actually, it is stuck on the screen with just the search still. So you'll have to share that new tab, which if you go to present and then share that one, it'll bring you to it. But it looks like it's a new tab.
Stop sharing screen is where it says present. So I don't know if I want to do that.
Yeah, why don't you start with stop sharing screen and then you'll be able to share a new one. So if you go back to present, share screen.
Okay, so now you see NEA versus New Hampshire Attorney General?
Yes.
And I'm scrolling through it very quickly. So what I was going to do was Command F mental health to see where it discusses mental health. And so here it referenced a case that had the word mental health in it. And it actually, there are 14 instances of that. But it's not really that much. It had the word fundamental. So it's really not that specific to our issues that we're wrestling with. It's an interesting case. I did read it, but so I can go back to the beginning and give you an idea as to. It had to do with the state, the NEA sued basically the state of New Hampshire about the anti-DEI laws, and if a school engages in DEI-related activity, they may lose their funding. And this was actually a very interesting case to read because the judge talked about DEI and what was going on and gave some history. And this just came out. But that's not why we're here today. So this case came out October 2. So I'm going to go back to individuals' disabilities education. And I don't know, I'll say now share this tab instead. So I'm back now at the sort. And so here's a whole bunch of cases. And I found one that was kind of pertinent. So let me scroll down here. Let me go to number 2. Talked about kids in mental health facilities. That's why that one popped up. I'm in Virginia, and this is and Powhatan County is here. New York versus Trump. Let's see. There was one case that I thought would be very interesting. Bear with me for a moment. Let me change my own screen for a second and find my reference to it. KL versus Dunmore. KL versus Dunmore is what I'm looking for. There it is. So right click on it, open it in a new tab. So I'm going to click on that tab, and now I have to share that tab. And this is almost a sign of our times in terms of the issues. So this case came out September 24. Can you hear me okay, Chloe?
Yes, I can hear you on the right
and you
screen.
See the case. You see Dunmore School District?
I do.
Okay. So this was a civil rights case brought on behalf of a child by his parents. They filed a 14-count complaint. He was a 14-year-old 8th grader, and JM used a cell phone to photograph the youngster while he was taking a leak. And the photograph was then shared with a bunch of other students. And the other part about this is that the photographer is a transgender child. And so the parents sued the parents of the child, sued the school district, sued a bunch of other people, and the judge in the end basically said a lot of these facts are egregious, but they don't arise to a violation of the federal law, but there may well be a violation of some state laws, and thus going to dismiss the case, but allowed the parents to refile the case in the local state court. So then I said, well, wait a minute, this is interesting. I want to see what they allege. I want to look at the court's file. So one last thing here. Right here is the number of the case. So I'm going to copy and paste, or I'm going to copy 3:24CV01461. I'm going to copy it into my memory. And then we go to another tab called Pacer. I use Pacer a lot, several times a day. I'm going to log into Pacer. And I've got to share this tab. Now, do you see Pacer on your screen, Chloe?
Yes.
Oh, perfect. Okay, good. So And in our law book, I explained all of this, how to use PACER. You only have to have two pieces of information, the number. So I copied and pasted that. And we want to get rid of the period. And we might not need the 3:, but we might. Sometimes you do, sometimes you don't. And then where was that case? I forgot where the case was. There it is. Oh, Middle District of Pennsylvania, MD, Pennsylvania. So then I go to region, and I'll go to Pennsylvania. And I'm almost ready to wrap up, Chloe, once we get to this. I'm running a little bit behind schedule. And this is middle. So I click the middle and I put the case number in there. And then go to the bottom of the screen, search. And here is the link to the case, KL versus Dunmore. And I've just clicked on the it opened up now the court's file, the electronic file, and I'm going to click on docket report. That's what you always will want to have. And here's the docket report. And with the docket report, I'm going to say run the report, lower left-hand corner. And what we have here is here's the complaint that was filed. I can click on that and I'll get the actual complaint was filed in the court. I can go all the way down to the end and find the briefs that were filed and everything else. So let me just go ahead and do that. And then we're about ready to wrap up on this. And I don't want to download. I don't need the cover sheet, but I do want to view. I'll unclick the cover sheet, and I'll click on one and view selected. View it. This may take a second because it said it was like 40 some odd pages. Oh, here we are. So here is the actual complaint filed in the U.S. District Court by the attorneys on behalf. And in that docket report there, it told me who were the attorneys, et cetera. So I'm going to now stop sharing this one, and I'm going to close these so I can get back into the PowerPoint slides. And
you can click those at the bottom there, the PowerPoint slides.
Okay. Oops. So do you see rules of negotiating?
Yes.
Perfect. Okay, so I have to move on now because we've gone way beyond that.
It's okay if we go a little over because we can send a recording to those of you that will need to leave right at 2 Eastern time. So we'll send that out.
All righty. Well, we've only got 4 more slides.
Okay.
So alert if you want to get an email every time the case comes up. And I get flooded with, I get probably about 10 emails a day from Google Scholar because of cases coming out and things that I've searched. So we found that, and then when I found the cases, I sorted them by date. PACER, it does cost you, but not much. You will not, if your bill is, well, first, it's 10 cents a page. And if any document is more than $3, like that was a 97-page complaint, I believe it was, my maximum fee for that, my maximum payment for that is $3. So no matter how long it is, the maximum is $3, no more than 10 cents a page. And in any 3-month period, if your total bill is less than $30, it's waived. You get no bill. So PACER, public access to court's electronic records, open to the public. And you can get audio files too. And so that's it. So I'm ready now for Q&A. So I guess turn off my screen sharing then at this point.
Sure. Yeah.
If I can figure out how to do it. Okay. I'm not used to this platform.
Okay. Well, before we get into the Q&A, I just wanted to say thank you so much, Pete. You've shared so much valuable information with us today. We really appreciate you sharing your time and expertise. For the Q&A, please feel free, those of you, we still have a pretty big group, so if you have any questions, feel free to post those in the Q&A section of the chat. And then our first question we have for you, Pete, is, do state laws trump federal laws?
That was why I had a couple slides on that. The Supremacy Clause of the U.S. Constitution makes it clear that the federal law is supreme. And so federal law trumps state law. But the federal statute in some areas, especially in the special ed statute, it does permit states to have different this and different that. More often than not, they have to do with rules of procedure. For example, to determine whether a child is eligible for an IEP on the initial evaluation, the federal statute says it has to be within 60 calendar days from the date of the school district's receipt of consent. But if a state has a different timeline, then consistent with the state's timeline. So that allows some states have a longer than 60 days, but some states have shorter than 60 days. So,
Okay.
but typically only with procedural issues, not with substantive rights. And the federal statute will make that clear. It will say in the language of the statute that it is permissible for states to have something different.
And then let's see, we have another question. So can I sign up for Pacer and never be charged if I keep my monthly cost less than $30? And does the initial sign up cost money?
The initial sign up does not cost money. And if your quarterly bill is less than $30, you will not get a bill.
Okay. And then we have another question. So I work at an independent pre-K to 12 school. Does Title III of ADA apply? If so, is it only for our preschool?
It applies basically to any public entity that is not publicly funded. In other words, for your mental purposes, think private accommodations or private schools, then it applies. The exception is limited strictly to schools that are controlled by religious entities. And typically that would mean a school that is located in a church and controlled by the church. But otherwise, there are many schools and many daycare facilities and nursery schools that are housed in churches, but not controlled by the church. Therefore, ADA applies. ADA protections apply.
Okay. And then we have another question. So if you could change one law or regulation in special education that you feel is particularly unfair or counterproductive, what would it be?
Wow. Well, it would, I guess it would have to go to the issue of, and it's really not a law, it's a concept, free appropriate public education. What does it mean? Originally, when Congress worked on this, some legislators wanted it to simply say the right of access to the schoolhouse, but nothing more. No specificity about the nature of the program. And others said, if you don't have any specificity, then you could argue that FAPE means using Braille with a child that has a hearing impairment and using American Sign Language to a child who is visually impaired. I mean, bizarre. So some wanted simply the right of access. Others said, no. It's got to be an educational program that maximizes the child's potential commensurate with the child's ability, maximizes the achievements commensurate with the child's ability and potential. And they said no to that too, because that meant you're looking at what is best for the child, and the word best is a 4-letter word, typically in special ed issues related to the word appropriate. And when parents were in my office and they would say, Mr. Wright, we just want what's best for our child, I would put my hand up. Stop. Best is a 4-letter word. Don't ever use that again, ever. You're not entitled to what's best. And if you use that, it'll be used against you later in litigation. So don't ever say it. So what's happened now, Chief Justice Roberts in the Andrew F. case talked about looking at the child's potential. He changed the landscape about the definition of what is an appropriate education in a very positive direction. The last 4 decisions in the U.S. Supreme Court were all pro-child and unanimous. And that potential one, so now, if there was anything that could be changed, I would like for Congress to take the exact words of Chief Justice Roberts there in his definition of FAPE and put it into the statute so it is crystal clear. That would be it. So you're looking at looking at the child's potential and taking that into account as you're coming up with an IEP. All righty. So,
Okay. Well, thank you for answering these questions. And thank you again, Pete, for all of your time today, for sharing your expertise. We really appreciate that. And thank you to everyone that's joined us today as well. We appreciate the work that you're doing every day as well, and supporting students and school communities, and then still making the time to for professional development activities such as this one. So from all of us at August Schools, thank you again, and we hope to see you at a future webinar. Have a wonderful day.
thank you very much, Chloe. Thank you.
Thank you.
Bye.